You're watching The Legal Breakdown. So, Glenn, we have a really important question here. I wanted to start off with this one. If the Fulton County case is removed to the federal court system and Trump wins the presidency, can he pardon himself?
No, everybody can exhale, because even if the federal judge transfers Donald Trump's case from state court to federal court, it remains a state case. It just happens to be a state case that gets tried in federal court, so it is beyond the reach of a presidential pardon. Neither Donald Trump nor any other president can pardon that kind of a case, a state case that gets transferred to federal court.
So is the reason they're trying to remove this to the federal court system just to get away from a Fulton County jury then?
That is the main reason, because the federal jury pool is somewhat broader. It's more diverse. It's not so sort of intensely blue as some people have suggested a Fulton County jury pool might be. So that's probably the biggest reason. But the secondary reason is if any of the federal officers, and that's who these motions to transfer apply to, only federal officers, not fake electors or anybody else. If the federal officers like Mark Meadows, Donald Trump are successful in getting the case transferred to federal court, it may open up a defense that they have available. That defense is, I was acting within the scope of the official duties as a federal officer, and therefore, Judge, you should dismiss this case. Here's the good news. Even in the unlikely event that the judge orders one or more defendants' cases to be transferred to federal court, he's not going to dismiss the case, because even if a Mark Meadows or a Donald Trump happened almost by default to do something that was within the scope of their official duties, they did so many things that were beyond the scope, that were outright criminal and beyond the scope of their official federal duties, that I don't think there's a chance in hell a judge dismisses the case. But that is a secondary reason why they want it over in federal court, because that defense gets a little bit more play in federal court.
Okay, got it. Now I want to introduce some audience questions. We've done an episode of just audience questions before. They were outstanding questions, and I've gotten a raft of new questions, so I think that'll be really interesting for people to watch. First off, we know that Trump seeks to delay court proceedings until well past the election. That's his goal here. What prevents him from getting close to a trial date and then changing his legal representation, and then the new representation would request more time to review the case material to prepare a defense? Is that a delay tactic that could work on Trump's behalf here?
Brian, to your viewers, to our viewers, that's an excellent question, and it's a problem that we encounter in the practice of criminal law. Sometimes a defendant's last-ditch effort to avoid going to trial is firing his lawyer on the eve of trial. But it's not that easy. Why? Because judges have seen these dirty tactics sort of pulled out of a defendant's trick bag time and again. And often the judge will deny the defendant's request that he be permitted to change counsel on the eve of trial. Now, let me tell you, it gets a little tricky, because the Sixth Amendment right to counsel is very broad and it's very pro-defendant, defense favorable. But if the judge has a record that can establish the defendant is playing games to try to avoid going to trial, he can actually deny the defendant's request to change counsel. But Brian, I can already see this one coming. I can see the defense attorney in the run-up to trial, John Lauro and some of his fellow criminal defense attorneys representing Donald Trump saying, oh, we have irreconcilable differences in the way we want to proceed in this trial, and we have to move to withdraw, and Donald Trump wants to fire us, so we can't possibly continue to represent him. I don't think Judge Chutkan will let him get away with that. Now, it's anybody's question as to whether Judge Cannon down in Florida in the documents and espionage and obstruction case will let him get away with that. But I think most judges are going to be on the lookout for these kind of dirty tactics being played by Donald Trump and his defense attorneys.
Right. If we out here can see it coming, then there's no doubt that a judge in the courtroom can also see it coming. All right, Glenn, another question here. We know that accepting a pardon is an admission of guilt. If Trump wins the 2024 election and then pardons himself, wouldn't that be a legal admission of guilt for the insurrection? And wouldn't that immediately render him unable to hold office under the 14th Amendment?
You know what? I would file that under the category of wishful thinking. It sounds good. There's some intellectual honesty to that line of reasoning. But I think the answer is ultimately no. Yes, the Supreme Court has said that a pardon carries with it an imputation of guilt. That's a quote from a 1915 Supreme Court case. But I don't think it is controlling or conclusive. For example, just because somebody accepts a pardon or requests a pardon, that's very different from proving guilt beyond a reasonable doubt for any particular offense. I think the optics would be bad. I think the politics would be terrible. I even think if a criminal case could somehow be brought afterwards, the evidence that Donald Trump asked for a pardon, received the pardon, or pardoned himself might actually be admissible to show his own guilty knowledge. But I don't think it's the be all and end all, and I don't think it would end up disqualifying him under the 14th Amendment, Section 3, for having participated in an insurrection.
One of the questions I've gotten most is related to Lindsey Graham and Ted Cruz. Why aren't people like this? Why aren't senators like Graham and Cruz? Why aren't members of Congress like Marjorie Taylor Greene or Lauren Boebert? Why aren't they being charged with anything related to the insurrection? Why are they kind of getting off scot-free here?
They have not yet gotten away with their potential crimes in the event there's enough evidence to conclude they committed crimes. Here's why I say that. Jack Smith, as special counsel, was appointed to investigate Donald Trump and the crimes he committed. But Merrick Garland and the career federal prosecutors at the Department of Justice can still investigate, and I'm going to go out on a limb and suggest they likely are still investigating members of Congress, because that investigation doesn't suffer from the same conflict of an investigation and a prosecution of Donald Trump, because Donald Trump is an announced candidate against Merrick Garland's boss, Joe Biden, for the presidency. That's why there is a conflict. Merrick Garland can, and I hope is, continuing to investigate every last member of Congress who may have been culpably involved in the insurrection. Guys like Ted Cruz, guys like Lil Runnin' Josh Hawley, who is, giving aid and comfort and urging the insurrectionists on with his tiny upraised fist. I hope they're being investigated. I hope they are charged if the Department of Justice and the prosecutors believe they have enough evidence to charge. But I do not think we've seen the last of potential criminal charges against members of Congress.
Okay, and finally, let's end with this. We've seen this issue kind of present itself, I think, most recently in Fulton County. How will jury members be protected, even in the case that limited biographical information is distributed to both parties in the case? Like, why not make an exception in cases involving right-wing political violence where the defendants are known to hunt down witnesses and jurors?
It's such an important question, because no juror should be called upon to do their civic duty and run the risk of being harassed, threatened, assaulted, or worse. Let me tell you, when I tried RICO cases many years ago against the biggest, most violent RICO conspiracy criminal enterprise in Washington, D.C., we took some extraordinary security measures. Let me tell you what some of them were. Our jurors were anonymous. We didn't know their names. We didn't know their identities. We knew enough about them that we could decide during jury selection whether we thought they could sit fairly and impartially as a juror and decide the case or not. But we didn't know who they were. We sure didn't know where they lived or where they worked. In fact, the U.S. Marshals bust them to and from court every day from an undisclosed location. Some of the other, and mind you, Brian, the criminal enterprise, the organization that we were trying, still got to some of the jurors, and those jurors had to be dismissed during the course of the trial, and we had to replace them with alternate jurors. We were also, believe it or not, back in the day, we were behind bulletproof glass that separated the audience, the public, from the well of the court, where the defense attorneys, the defendants, the jurors, the prosecutors, and the court staff was. And then the other thing, the judge had ordered that the defendants were to wear 100,000-volt stun belts under their suits in the event they acted up, because this was an organization that was known for killing rivals, killing witnesses, attacking law enforcement, and killing their own crew members if they tried to leave the criminal organization. That equaled death. So we take these things deadly seriously, particularly protecting jurors. So I hope the judge will consider making the jurors anonymous, not letting anybody know where they live or where they work, and keeping the cameras off of them at all times, because we now know that there will be cameras in the courtroom, at least down in Georgia. We haven't crossed that bridge yet with respect to federal prosecutions, but the system needs to go above and beyond to make sure these people who are called to do their civic duty are not put in harm's way.
All right, well, we'll leave it there. To anybody who submitted questions, thank you so much. Obviously, these make for some of the best episodes. I think Glenn would agree. I'll also put a community post on the community tab of my YouTube channel, and I'm going to ask and solicit more questions for another episode of viewer submitted questions. So check out the community tab on my YouTube channel, and we'll get another episode going just like this one. So with that said, to follow along with this stuff, make sure to subscribe. The links to both of our channels are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.